how you are able to communicate with the other parent, or the parent is able to communicate with you, weighs heavily on the court.
We can see all of the mistakes people make after they make them. Sometimes in real time, but most often we're looking back.
You start getting into these increased moments of anger and fear that you take a pause.
Being highly emotional, even volatile, during a custody and placement dispute is normal. Why? Because you never signed up to be a part-time parent. You knew all along that you wanted to be a full-time parent, and now it's threatened. It's absolutely important to understand what goes into this process, and any mistakes or misconceptions need to be cleared up before it's too late. So let's be honest. People mix up and confuse the terms custody and placement all the time. Sometimes they think they're the same thing, sometimes they flip them, sometimes they just don't know what they are. So let's go through this and straighten everyone out once and for all, okay? There's joint legal custody, sole legal custody, joint legal custody with impasse authority. There's shared placement, there's primary placement.
Custody deals with the decision making. It deals with where your child's going to go to school. It deals with where they're going to go to church. It deals with whether or not they can get a driver's license at age of 16. Those custodial decisions. The court is always going to value that each parent has an equal decision making process, has the ability to weigh in on those decision making factors. Placement deals with where your child is going to lay their head at night. So how many overnights are they going to be at one parent's house versus how many overnights are going to be at the other parent's house? Custody and placement's easy to confuse because you always hear them put together. But when you go into court understanding custodial decisions are going to be those decisions that we make together. Placement is, again, where your child's going to sleep at night. And how are placement arrangements going to be made? How are transportation arrangements going to be made? Who's going to pick up? Who's going to drop off? From what location is that going to happen? Who's going to have on specific holidays the minor child? Who's going to have over summer or spring breaks? How are those decisions going to be made? All encompasses placement.
So the court, if I'm saying this correctly and understanding this, the court starts at joint legal custody.
Correct.
So what are the alternatives?
So you can have sole custody where you're going to make all of the decisions for the minor child, or you can have custody with impasse authority. So let's say, for instance, father is out of the state most of the time, over the road, and is unable to make certain decisions. You can have mother having impasse authority where if something arises, such as a doctor's appointment, you can have joint legal custody with impasse authority over medical decisions. We see that oftentimes when parents go to court and they're fighting over school choice. Mom wants child to go to school A, dad wants child to go to school B. If the two are unable to communicate and the two are unable to reach a resolution, sometimes the courts, if they find it egregious enough, will say one party gets impasse authority over school decisions going forward so we don't end up here in court again.
Let's be honest. Custody and placement fights are dynamite charged. Raw emotions, complicated issues, frustration, alienation. It's important to understand how custody and placement determinations are made, what mistakes you can make along the way, how you can correct those mistakes, and ultimately how you can determine your outcome in a divorce. Tristan, I want to jump into a topic that I think a lot of people think about and want to know but don't really understand, okay? And that is parents' rights. Now, you and I as attorneys understand that parents' rights themselves kind of stop at the Constitution, which is we have biological rights to our children. But we practice in family court. And family court dives deeper into parents' rights, specifically into the right of custody and the right of placement, right? So when a court addresses custody and placement, they're really talking about parents' rights, aren't they?
Everyone has a biological mother and father here. So everyone has rights to be part of that child's upbringing, part of their rearage. So what we want to do is make people understand that when it comes to parents' rights, you're starting off on equal footing. Now, what can happen where you slowly you feel like your rights are being diminished. Well, your rights aren't really being diminished, but custody may have to be altered. So we talked about, custodial decisions with impasse authority, or one parent having sole custody over another parent's rights. When you talk about placement, a child spending more nights with mom versus dad, or dad versus mom, we're not diminishing your rights as a parent. What we're saying is, in the best interest of the minor child, what fulfills the needs that they need to flourish.
So it's not the rights that are jeopardized. It sounds like the allocation of those rights is what's being determined. Some party may have a greater share of placement or a greater share of custody.
Correct. But it doesn't diminish them to absolutely nothing unless you have no interest in your child whatsoever. If you have more placement time with one parent than the other time, again, it doesn't diminish your rights, but it's saying that what's in the best interest of the child is to spend more time at this house as opposed to that house.
You keep saying this term best interests, and it's, I think, a term that we hear often in our practice, but that really has significance. It's not just a part of a sentence. It really means something legally. What's the significance of that term, best interests?
So it's a statutory guidance or statutory factors that fall into what are the best interest factors for the minor child. There's actual case law that determines. There is law that determines what are the best interest factors. There are 16 best interest factors. The court will analyze those best interest factors when making a determination as to what needs to happen with the minor child. What best serves them in custody? What best serves them in placement?
I know that everyone could look up the statutes and read the statutes. Maybe lawyers enjoy reading statutes, and most people don't enjoy statutes. So could you do us a favor, and just in layman's terms, a couple of the best interests factors?
A couple of the best interest factors would be how the parents communicate. What is the historical perspective of the parents' relationship? Was domestic violence ever put into a factor? Is there alcohol? Is there substance abuse? Is there drug abuse? Those are a few of the factors that will guide the court as to what is in that best interest of the minor child.
So the court's going to look at each of the parties and whether they can be nice to each other or whether one is being a jerk to the other. Is that way to say it?
How you are able to communicate with the other parent, or the parent is able to communicate with you, weighs heavily on the court. If, for instance, you have a restraining order against the other party, well, that diminishes the ability for the two of you to communicate.
We get the benefit of lawyers in many ways of being omniscient and having hindsight as our benefit. We can see all of the mistakes people make after they make them. Sometimes in real time, but most often we're looking back. So what are some of the mistakes people make that maybe they're not even aware of that dramatically affect the downstream outcome on custody and placement decisions?
Letting your emotions get the best of you. When you are dealing with a situation that involves a minor child, your sense of security or your fear is going to take over. And you are going to say things you don't mean to say. You are going to text things you don't want the judge to really be seeing. You're going to be doing the things that you wish you could take back. Things such as, I give up on custody. I don't want to deal with custody anymore. Or, you know what, just take the kid. I don't want the kid anymore. Those are the things that you're going to memorialize and wish that you wouldn't. The idea is that when you start getting into these increased moments of anger and fear, that you take a pause and you understand that what is your ultimate goal and what are you hoping to achieve? And whatever's about to come out of your mouth next, or whatever you're about to text next, is that really something you mean to say, and is that going to be in furtherance of your goal?
Probably worth discussing right now. So I'm old. You're not as old as me. I used to talk to people on the telephone. Seems like more people now aren't having conversations by phone. They're having conversations by text, by messenger, by all forms of social media. What's the impact from a lawyer's standpoint on that mode of communication?
Never, ever put anything into writing that you don't want a judge to see. That is the easiest thing that the standard rule that I wish as an attorney I could scream from the rooftops. Do not put anything in a Facebook message. Do not put anything in a text message. Do not put anything in an email that you would not want the court to look at. Because eventually, if custody, if placement become heightened, you're going to be surprised how much of that comes back in. Additionally, with the way that technology has improved, now you also need to be careful about the things that you say over the telephone because everything is recorded.
Bottom line, concerning any custody and placement dispute in the state of Wisconsin, the courts must follow the statutory guidelines to determine what's going to be in the best interest of the children. At the end of the day, the courts are always going to try to figure out what's going to be the most healthy, cooperative environment for the children. It is absolutely imperative that if you are in this situation, you find an attorney who is experienced and expert in this area.